Landlords, don't make this mistake of putting up with crappy tenant behavior regarding gaining entry into a rental unit. Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, I just talked with a landlord just now about they were having problems getting access into a rental unit. In this case, it was to perform some inspections needed for the sale of the property. The tenant refused entry several different times. And this is kind of a recurring theme that I hear a lot, where landlords will allow a tenant to refuse entry on multiple occasions after trying to informally work with them about doing stuff, and then they throw their hands up in the air and say, I just give up. No. Okay, that ends now. Okay, I want to tell you what the solution is. Okay, and it's quite simple. Okay, so under California law, a landlord can enter the rental unit on certain conditions. Okay, and the two main grounds of how you can enter the unit is one, through consent, and second would be by a lawful written notice. And that's all prescribed under Civil Code 1954. Okay, and the landlord can make entry for several different reasons under Civil Code 1954, such as to effectuate necessary repairs, to facilitate the sale of the property, for example, showing potential buyers the property, or to conduct necessary inspections. Okay, what this landlord made their mistake was they just allowed the tenant just to kind of do whatever they wanted to do. Okay, I always recommend, if you can't informally work out with your tenant entry, you're going to have to go the legal route. Legal route is giving a formal notice of entry. Generally, the law says you have to give at least 25 hours notice. Okay, my recommendation is the more notice time you can give to a tenant, the better, because if the tenant refuses entry at that point upon a lawful notice, you can give them a 3-day notice to perform. Usually under most agreements and the law, you have to warn the tenant, telling them, hey, listen, you are unlawfully denying me access to the property. Another tip that I like to give landlords is I like to keep my entries during normal business hours. Okay, it says like regular business hours under the Civil Code. My definition would be do it during like Monday through Friday, 8 to 5 p.m., like whenever the Superior Court is open. Okay, because guess what? When your tenant, we end up in court and your tenant's complaining about, oh, you wanted to make entry on a Monday at 9 a.m. in the morning. My argument's going to be, Judge, the court is open during those business hours. Okay, and we gave the tenant ample notice. And in this case, we gave her like 2 weeks notice, basically, that we needed to do this inspection. And yet she refused to do that inspection. And then that way, when we do the 3-day notice to perform and the tenant doesn't comply, we ever end up in court, the tenant just looks unreasonable, basically. And my argument would be, Judge, we tried informally. We did the formal notice route during normal business hours, like when the court's open, and this tenant still wouldn't let us in. And we're trying to get our inspections done, and that's allowed by law. And hopefully I can get the judge to browbeat the tenant and go what are you doing? And then there you go. So those are my tips. Folks, you got comments, questions, put them down below. If you are facing this problem and you're in the Northern California area and you need help getting through a tenant that's denying you access to the property, feel free to reach out. We might be able to help you out. Until next time, folks, I'll talk to you then. Thanks.